Yes, of course.
This pretrial review is in the matter of CFI 106/2021 and is being held by way of video conference before Justice Michael Black, KC, with a sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by DLA Piper Middle East. Lead counsel is Lord Jonathan Marks. The defendants are represented by Horizons & Co. Law Firm. Lead counsel is Mr. Riaz Hussain, KC. Thank you, Your Honor.
Thank you very much indeed. And thank you both for your notes, which I have received and read. Thank you very much. I ought to confess that I've encountered some rather major technical issues this morning, so I've not read as much of the case file as I would normally have done so, and I apologize if that creates any need to explain some things to me in a bit more detail than would be usual this morning. But having said that, Lord Marks, would you like to go through your note?
Your Honour, yes, I would. May I simply make one point without any hint of hostility, but I've received a note from Mr. Hussain this morning, literally about half an hour ago, with some.
Well, that's rather earlier than I received it. I received it 16 minutes ago.
We're on it. Yes, but very recent for both of us. I've got a couple of points on it, but I'm not in a position to deal with it in any detail. And although I quite appreciate that Your Honour won't have had a chance to absorb the detail of the case, what I suspect is that most of the issues this morning are relatively straightforward and procedural. Your Honour, I don't know whether you'd wish me to introduce the DLA Piper team.
No, I can see people up on the screen anyway, so that's fine.
Your Honour, that's fine. So Your Honour will have seen that both parties have submitted a checklist. As to the defendant's checklist, there's just one short point that I would make, which relates to costs. We've put in a note that says our costs, the claimant's costs to be incurred, are 1.372 million dirham odd. The defendant's costs estimate says that their costs to be incurred are just 271,000 dirhams, which I take to be disbursements. And if I could ask the Horizons team to add the full figure, that would be of assistance, I've no doubt, to the court as well as to the claimant's team.
Yes, 271,000 does sound a bit light for a 2-week trial.
Yes. Well, that's the point that I make on that. All that I'd say at this stage about Mr. Riaz's note, and I'm sure he's going to introduce it, is that he appears to introduce for the first time a dispute on the meaning of clause C6 of the addendum. And he refers to the particulars of claim at paragraph 52.
Yes.
And I don't know whether he's had an opportunity to see that in paragraph 8.2 of the defense on page 11 of the defense, paragraph 52 is admitted insofar as it reflects the contents of the subcontract and the addendum. However, it's denied that the claimant has any entitlement to its claims pursuant to these clauses. Paragraph 52 of the particulars of claim sets out what the claimant says is the effect of clause C6. The provisions of the subcontract and the addendum entitle the claimant to recover all of the costs it has incurred in completing the subcontract works on behalf of the first defendant, the claimant refers to without limitation its rights under the following clauses, emphasis is added, and then two of the subclauses are set out at 52.1 and 52.2. If and insofar as the only dispute is as to whether the defendants are entitled to credit for the contract price that they would have been paid had they completed the contract, then there is no dispute, and the experts have agreed on that, and the tables make that quite clear. The tables both in Mr. Kenyon's report and in the joint minute. Of course, credit has to be given against that contract price for the sums that had been paid. And if that is the only concern that Mr. Hussain has, then there may be no difficulty. If, on the other hand, he seeks to go beyond that and to say something else about the meaning of Clause 6, then particularly in view of the admission of the claimant's position, he must, with respect, seek permission to amend so as to say what he is actually saying. And a note that you received 16 minutes ago doesn't do the trick. And I say that particularly in the light of the fact that he says that the note is raised at this stage, given the direction for sequential opening submissions, to avoid this perspective being raised for the first time in the defendant's opening. And Your Honour will remember that the claimant's skeleton opening is due on the 7th of October, and the defendant's skeleton opening on the 14th of October. It would be entirely wrong for a new dispute as to an admitted passage in the pleadings to be raised a week before the trial.
Well, shall we hear what Mr. Hussain has to say about that immediately before we go to other matters?
Your Honour, by all means.
Mr. Hussain.
Your Honour, do you have the defence at hand?
I can bring it up if you bear with me. Yeah, I have to go through, I'm afraid, the...
It might be that I can share my screen, bear with me.
No, it's okay. I can, of course, inevitably the case management system freezes up on me when I try to do it. I'm sorry, it's the case management system taking a very long time to take me to the defense. Okay, all right, it's come up. So sorry, now I need to find the defense. It might have been helpful to have an application bundle. But, where is the defense? Reply to the defense. Defense. All right, let me get that up. Open that. So I'm just waiting for all these documents to open. Right, I have the defense.
Your Honour, if you can go within that PDF page 21. There's also the numbered page 21.
Have it?
I invite you to read paragraph 10.1. I'm slightly surprised by my learned friend's statement that this is a new case. The defendants submit that clause C6 of the addendum does not place D1 under an obligation to indemnify the claimant against the additional costs incurred in completion of the subcontract works, or any obligation to repay amounts received. And the claimant's reliance on clause 6 in this connection is both factually and legally flawed. And the reference there is to paragraphs 88 and 89 of the statement of case.
Yeah.
I might have to trouble you to go back to the statement of case.
Okay.
Sorry.
Now, I did have them up earlier this morning. Question is whether they're still there. Yeah, I've got the particulars of claim.
Sorry, I should have called it particulars of claim. If we go to 27, page 27 of that, we're looking at 88 and 89.
Page 27, right. Okay. Okay, got that.
And that is where it's pleaded that the claimant seeks to recover a total amount of 104 million dirhams, which represents a cost incurred by the claimant in relation to the subcontract works, less the sum called in the bonds, and less the value of works recovered from the employer. And then it says the claimant's approach is in accordance with clause C6 of the addendum. And that's squarely denied. I'm not sure how this can be said to be. I mean, this was a central point in the case. The reason I put in the note wasn't to spring a new case on you. It was because I think it's important for the judge reading into this to see that actually, depending on what you find on the meaning of C6, certain claims may not arise, or we need to understand if they still arise, the alternative.
Okay. Well, it's not something I can decide.
Yes,
now.
of course. I wasn't able, maybe in a way, I'm glad I raised it because there seems to be a misunderstanding. I wasn't intending for you to decide it or spend any length of time on it. But what I wanted to do, or the aim behind the note, and I apologize for being late, it's entirely my fault. The aim behind it was just to say, well, there's the perspective we say to reading into this case should be, well, a lot depends on what this clause means.
Okay.
Regardless
well,
of
it rather looks like this is going to come out in the wash in the openings, unless
yes, of course.
Unless Lord Marks has a problem with that.
Well, I don't have a problem with hearing what I now hear. I mean, the difficulty that I have is that the experts, the quantum experts, have quite clearly dealt with the slightly confusing words recovered from the employer, and they've changed them slightly. What is intended by the deduction is effectively the value of the subcontract works being the subcontract price, taking into account any variations that are accepted, and credit is given for that. From that is deducted the amount of amounts actually paid. And I'm slightly surprised that this is a headline issue, since the experts have agreed, well, almost agreed on BAM's claims, because in the joint minute, Mr. Kenyon's figure for BAM's claims is 105 million dirhams, and Mr. Atherton's figure is 101,000, and that's from the table at paragraph 2.1.1. But in view of what Mr. Hussein has just said, it may be sensible if we try and identify any differences between us, identify whether really he's come up with an important new point in the case at issue between us. If it's important, then I shall maintain that he needs to set it out formally or informally as quickly as possible, to which I can respond. And if it's not of any great importance, then we can probably deal with it by agreement. I don't know whether that slightly informal way of suggesting a resolution appeals or not, but doesn't seem
well,
to me
it appeals to me, certainly. Whether it appeals to Mr. Hussein. Mr. Hussein, that sounds rather sensible, doesn't it?
Yes, of course. And again, no one is expecting at the PTR for the court to be delving into this. I think it's been helpful for us to have this discussion. I suspect what it emphasises is the need for quite the importance of the oral openings, and to avoid a situation where the parties, I mean, we have sequential openings, so that's useful, but we want to avoid a situation where our written openings are kind of ships passing through the night.
Absolutely right. I mean, obviously you have oral openings after the written openings,
Yes.
Which enable you to comment on each other's written submissions. But I'm clearly very much in favour of liaison between counsel and agreeing as much as possible.
Thank you.
So,
Thank you very
shall I
much.
continue with the schedule
Please
set
do.
out in my skeleton argument?
Yes, please do.
Now, the defendant's outstanding application for the admission of new documents has not yet been resolved.
No, I was actually, that was actually passed to me 2 days ago, so I apologise.
There's absolutely no reason why you should have resolved it. Indeed, the defendants did have an opportunity of putting in further evidence, which they've decided and notified us by a letter of the 18th of September that they were not going to do.
That's probably why I got it. That's
Yes.
probably why it was referred to me on the 19th.
Yes.
Yes. Right.
I expect that's right. I don't seek to add to the submissions made previously in relation to this, and
No, they're
included
pretty
in
full.
the
They're pretty full in those those witness statements. In any event, yeah.
They are, yes. The only concern that I draw to your attention is one that is set out in the skeleton argument as to what steps would be needed now in the event that the application were allowed. It seems from Horizon's letter, which you've now seen, that they accept that these are the steps that would be needed, and the timetable I don't think is in dispute. It's a further report from Mr. Atherton, the defendant's quantum expert, explaining the nature of their position as to the nature and the import of the fresh documents. We need that as quickly after the decision on the application as possible. We've suggested 4 days. Mr. Kenyon needs a week to put in a report in response to that report and to the documents. And then there would need to be a joint statement from the experts on the important effect of the further documents, for which we've said a week, and there's no quarrel about that. So I say merely that is 3 weeks to the time of the new joint minute from now, even if you were to decide the application in the next day or two. We are 4.5 weeks to trial. And importantly, from my point of view and DLA's point of view, only 17 days to the 7th of October, which is the date when the claimant's skeleton is due.
Yes.
We're preparing that skeleton against the background that the bundles are agreed and have been agreed today. But because the agreement was only reached on the electronic bundle, and that's because Horizon's only referred to DLA Piper last night with agreement of the contents, it is going to take till next Wednesday to produce that electronic bundle, which puts us under considerable pressure in relation to the preparation of the skeleton. And there would be even more pressure if we had to deal with a positive outcome to the defendant's application.
So the short point is you want me to get on with it?
The short point is I want you to get on with it. And I add to the point that given the timescale now, it's really quite important that it be refused. But that's, I don't want to add anything else to the...
No. But as if the parties are sort of satisfied with a quick and dirty decision, I can probably do it over the weekend.
I think quick and dirty would do the trick rather than slow and even more difficult. I mean, the other point that they'd make is that Horizons spend a great deal of time in their letter, or a great deal of their letter, it's not a very long letter, saying that there's no prejudice. They haven't, however, dealt anywhere with what they describe really as a series of complaints about non-compliance on the part of the defendants. And there is that long history of non-compliance, and there is concentration in Mr. McCallan's statement on that. And we don't apologize for that, because the longer and more serious a history of non-compliance, the more likely it is that a court will hold against an application for non-compliance. And of course, the overriding objective includes enforcing compliance with orders of the court. So even if there were only little prejudice, and we say it's quite substantial now, the defaulting party must face the consequences of that non-compliance if that is the decision the court wishes to take.
Right. Perhaps I want to hear from Mr. Hussain on that, please.
Yes, Your Honour. So the documents relate to a subset of the counterclaim labour costs. The experts have discussed that part of the counterclaim. The costs are derived from a histogram showing workers on site. The experts have noted that the documents that fed into that histogram were not available to them because they were created, or the histogram was created by a third party called Consulting House. Subsequent to that, my client got those documents, the documents that go into the histogram, and those documents have been with the claimant since August 15th. And it seems from what my learned friend is saying that the expert has been told not to look at them since August 15th, which is fine, that's their choice. But we're in a situation where the documents are clearly relevant. Their expert has said for some time now that he can deal with them in the days that he's indicated. I'm not sure how it can seriously be suggested that a large part of the counterclaim, documents that are relevant to a large part of the counterclaim as confirmed by our expert, should somehow be barred from the proceedings. Not least because Mr. Kenyon can deal with them in a number of days. The reason why it's getting closer and closer to the hearing is that rather than agree the adducing of the documents on this timeline, even till now, the defendant is seeking to bar them. So what we say is these are documents that can be dealt with. It's been confirmed. They're relatively routine documents for QS experts. It's entirely, although it's not ideal, it's entirely standard for quantum experts to continue talking even during the trial. If my learned friend will have difficulty in addressing a particular part of the counterclaim in his skeleton, obviously we are happy for that to be addressed in a separate addendum note or whatever it is. But we're not looking at cross-examining the quantum experts for a while still. So what we would request is that we get, in light of the acceptance that the matter can be dealt with, that we get that quick and dirty decision, as you said, soon. A bit surprised that there's still a claim to debar their documents, and then we can deal with how to accommodate in the skeleton and so on.
Okay. I have your respective positions, and I will do the best I can to get that decision out as quickly as I can.
Your Honour, thank you. The next point then that I would turn to is the timetabling of the trial.
Yes.
And this is an area on which you will have seen that both parties are completely ad idem. In my skeleton argument, I set out a day-by-day suggestion. The important points that I'd make, but they seem to be from my learned friend's note today agreed. The important points are that this is an indicative timetable only. We're agreed that there should be a chess clock time sharing system. And if we go short on some witnesses, we can go long on others, provided that we share the time equally. And I hope that you're happy with that.
Yes, I'm very familiar with chess clocks.
I've put in a note of caution, which is that there's little time for procedural or housekeeping arguments and little time for slippage. It may be, of course, that the witness evidence will take less, so that doesn't prove to be so much the case. But we, I think, both believe that the evidence can be heard by the end of the 28th of October, day 6. And we're in agreement that the 29th and 30th of October should be held in reserve. We've been clear that closings ought, in our submission, to be dealt with, and I'll come to that, in writing, followed by a day of oral submissions, if the court would be assisted by that, as we suggest the court would be, in which case we ought to finish the oral evidence and then have the break at the end of the 28th of October. And I think that's agreed, subject to Mr. Hussain making the point, or taking the point, that perhaps it would be best to leave what happens about oral submissions to the end. For our part, we don't see the point of that. It's quite clear.
But if we're going to have to reserve a day, then obviously with busy counsel and other members of the teams, it's right to get that in the diary as early as possible.
I absolutely agree. And it's also, I would submit, I'm moving on in the schedule now, I would submit relatively clear that this is a case where written submissions are going to be of assistance, and that oral submissions, as soon as the evidence is finished, are going to be of very little assistance because they'll only escape the surface.
Well, I have to say, I don't mean to cut you short, but I agree with you on that. I think, looking at the case, I am going to be best assisted by the considered arguments of counsel in writing and then expanded upon orally, rather than, as you say, skating across the surface, as one might do with oral submissions immediately after the close of the evidence.
Yes.
Subject to being convinced I'm wrong by Mr. Hussain, that's certainly my view. Mr. Hussain, just what you feel about that as a matter of principle?
Your Honour, I think we can certainly meet your concern. We can put a date in the diary for oral closings if needed, following the written closings, and we'll keep that date. And then you can then take a view on what's actually needed after close. I mean, often what works well in my experience is that you get the written closings. You may want certain points addressed in writing or differently, and then confirm whether you need the oral closings as well. But we can certainly put the date in the diary.
Yes, I think that's probably sensible. I think we should work on the basis then that we're going to have written closings, and so we don't need to timetable oral closings at the end of the evidentiary hearing. We will rise then. Question is, how long would the parties then want to put in their closings in writing?
Well, we've suggested a date towards the end of November.
What do you say about that, Mr. Hussain?
I'm just WhatsApping my solicitors. I've got good availability in November. I'm just waiting to hear back from Mr. Blakeway on WhatsApp. But just while we're here, Your Honour, this is not in a partisan way at all, but if we look at, and the timetable is agreed, but looking at my learned friend's note at item 6, I mean, there's a number of facets to this case. There is a question on what the meaning of the contract, which is quite important. There is a claim against D2, which takes in allegations of fraud, plus.
Yes, I've seen that.
Yeah. So, and then you've got the issue, the technical evidence and the quantum evidence, more on the counterclaim, points of difference on that. So we're looking at 4 or 5 strands. I suspect that the oral openings will be quite important, and you may well have questions as we're going along on various points. So it's not just a case of what does the evidence show us. Quite rightly, the pleadings are just pleadings, and they're questions of law that arise and the various issues that will start to be.
You've actually just prompted me to say something. In your, do you have a chess clock agreement as such?
No, but we'll make one, I'm sure. We haven't.
Yes, well, I think what you should do is exclude from both of your times my questioning. So it does. So my questioning will not eat into either party's allocation. And the suggestion of hot tubbing, which I'm reasonably sympathetic towards, I think perhaps if I decide to hot tub the experts, that too might be excluded from the allocation of the parties in terms of time. If that means that, you know, we sit for half an hour longer on certain days or whatever, so be it.
Yes.
That's noted, Your Honour. My solicitors have confirmed that we can make the end November date for the written closings. Just also can I add that it's agreed that we should, with good effort, finish within the 6 days, but it's not outside the realms of possibility that we need the reserve day. So I think we both understand those days to be really in reserve, not nominally in reserve. That makes sense.
Okay, well, I'll make sure I don't book my flights on those days. Okay, so we say the end of November. What do we mean by the end of November then? Somebody going to suggest a date?
The answer to that is yes, if I can find my calendar.
Or would you just like me to say that, I don't know, Monday the 25th or Friday the 22nd?
I think Monday the 25th would be more attractive because it gives the weekend finalised.
Good. Okay, we'll say the Monday the 25th. And to get a day in the diary, well, that depends on your availability. It's probably something you can't both give me at the moment, and particularly with legal teams involved too. Do you want to come back to the court on a date on a day in December, and I'll see whether I'm available on that day?
I think that would be very helpful. If I may suggest that we try and give 2 or 3 days so that your availability is more likely to be.
Yes, when you say 2 or 3, I mean
2 or 3
we will only
possible days.
list, yes, 2 or 3 possible days, but we're only looking at one day and
Absolutely.
remote, and you wish to do it remotely. It's obviously, as opposed to the trial, it's less cost effective to have you both flying out to Dubai for one day.
Yes, well, that was certainly my suggestion.
Yes. Yes, I mean, I will be in Dubai in December, but I'm happy to deal with a days here remotely.
I think far easier in the case of submissions than in the case of
I know. I don't have a problem with that, and it's a more economical way of dealing with it.
Yes. Well, Your Honour, thank you. As far as hot tubbing is concerned, I mean, I've identified just a few topics on which I think it might be helpful, but this ought to be a matter that should be capable of agreement, given your indication that you're in principle sympathetic to it without any commitment one way or the other.
Yes, yes.
I mean, what I think is important is that you should hear the technical experts on whether the tender or IFC drawings are properly to be taken as the basis of the design. Secondly, the whole question of panel sizes and the area of responsibility and what was envisaged. And thirdly, the need for hexagonalization of the steel surfaces of the panels. There are more topics that may well benefit from hot tubbing, but those
can I suggest this again? Forgive me. Sorry to talk over one of the problems with remote hearings. Forgive me, but can I suggest this, that it might be helpful for you to perhaps include, just as an addendum, a schedule to your written opening of the issues that you think might be helpful to be dealt with in witness conferencing, and I can have a think about it. And indeed, Mr. Hussain can have a think about it too.
Yes, I completely agree with that. It may be that we can do that by liaison first as well.
Yes, of course.
So
again,
see if we can agree something.
Yes, cooperation is always encouraged. Yes, absolutely.
As far as the next point, point 7 in my skeleton, the document arrangements,
Yes.
the bundle that's on the portal is now agreed and on the portal, and that's there for all to see. The electronic bundle for documents that can't be uploaded to the portal, the contents were agreed last night. What the plan is that DLA Piper will prepare USBs which will have all the documents hyperlinked so that they'll be easily accessible. And the USBs with the hyperlinking should be ready now by next Wednesday. And I hope that's acceptable. It's only 3 working days from last, well, 4 working days from last night, including today.
No, that's absolutely fine. And I'm sorry, I'm just looking at bundles here on the portal. Forgive me for 1 second. I don't think. What have I got? The last thing I've got, yes, trial. Yes, I've got access to it on the portal. But what I'd actually like, I'm not. It's terrible to say this, but I'm not the greatest fan of looking at documents on the portal, and I always use a local copy PDF on my own computer. So I would welcome a drive, separate drive with all of the documents. If it's hyperlinked, even better. It saves me doing it myself, which I otherwise tend to do. So yes, and certainly next Wednesday it's fine by me. But I would very much welcome a copy of the bundle that I can then just upload or download onto my own local machine.
So basically, if we provide a USB with all the documents that are on the portal as PDFs.
Yes, plus the native spreadsheets as well. You said which you couldn't upload.
Yes. Yeah. Yes. Well, I'm sure that can be done. I mentioned in this section of the skeleton the question of hard copies. Would you like us to make hard copies of any of the principal documents as well and put them in a bundle?
No, thank you.
You're techier than I
am. I do sometimes print documents out for myself if I think it's useful. Sometimes the pleading, but I don't ask the parties to do it.
It'll be my chambers who do it for me, but I will have some.
Yeah.
Closings we've now discussed, and you've given an indication in relation to that. And the last question is live transcription.
I've got strong views on that. I can tell you right away, I regard it as essential that I have access to a live note or equivalent.
Yes, and there's another aspect that now comes with that is very important in my submission, which is that when we're having a number of witnesses, as we are, particularly the expert witnesses, the reference to documents should be handled by the live transcription service. They usually provide them side by side. That will mean that documents that are referred to will be flashed up on a screen that everybody has access to very quickly, rather than people having to wait for the last person to get it up.
There are two things here. I'm going to get techie again, I'm afraid. There are two. When you say it should be handled by the transcript providers, are you talking about a full-blown Opus type system where the actual transcript itself is hyperlinked to the documents? Or are you talking simply about having somebody who is has an EPE operator there who will put them on the screen as the witnesses give evidence?
I've used both. I was talking about the latter as an essential, the former as a useful add-on. But if we can't have the hyperlinking service, I don't know the difference in cost.
Well, the costs are significant.
Yes.
Well, in
what is
relation to the
essential, though,
former.
is to have the documents flashed up on the screen in front of everybody, so that we don't all have to wait for the last person to get them up.
Yeah, I agree with that, and I think we have the ability to do that quite easily in court. And so the question is whether the parties themselves handle that, or whether you get it handled by separate professionals. I'm going to leave you to discuss that.
Yes, I mean, I think we're agreed that since the transcribers generally will OPUS certainly do, and I understand there's another firm now operating in the DIFC called Teres, with whom my solicitors have been in contact, and there's
Well, yes, I'm told Teres. Well, Teres are interesting because Teres actually use an AI transcription service, which I'm told is I don't know is much more economical than other transcription services. I saw a demonstration of it in Singapore quite recently, and it was impressive. And I know it's been used in a number of arbitrations, so that might be quite interesting.
Yes, DLA told me that Teres was used in the DIFC, I think, as recently as last week, but
it's not been used in the court. I'm not aware it's been used in the courts, but maybe it hasn't. By other judges, I don't know.
I don't know. Miss Janveri is on the line. She can tell me if I'm wrong. It came from her.
But I do know. I do know
way,
we've been looking at it. We've actually been looking at it. That I do know.
Yeah.
That I do know.
But I can quite see Mr. Hussain saying that a quote's got to be obtained. But DLA Piper have been badgering Horizons to agree to this in principle for 2 weeks. And given your indication that it is essential to have the transcription service and to have the exhibits on and the evidence on the screen, then I'm quite sure it's going to be arranged. And it's my submission that the costs should be shared equally between the parties in the first instance, and then be part of the costs of the hearing when costs are determined.
Yes, well, I think I'll hear from Mr. Hussain in a moment, but he said, I think in his skeleton, yes, as long as they have access to it. Of course, they must have access to it,
Yes.
And an equal sharing of costs ensures that.
Yes, I mean, I agree. The idea that you can not share means that nobody can quote from the transcripts and nobody can look at the evidence. I don't understand how it works without sharing.
No. And for me, as I say, it's essential when I come to write the judgment to have that material, because I will annotate the transcripts I go along.
Well, with that indication, I'll leave the subject, and Mr. Hussain will no doubt say anything he wishes if he disagrees.
Yes, thank you, Mr. Hussain.
Your Honor, I mean, with my lawyer hat on, obviously, I can see the need for the transcript. The difficulty I have is I haven't got instructions as yet to agree. So I'll leave it in your hands.
Well, I'm going to order. I will order it.
Yes.
If that makes life easier. And I will also order that the costs are to be shared equally between the parties, subject obviously to the reallocation on the final disposal of the cost issues. I'm
in your hands, Your Honor. Thank you.
Right, Lord Marks, anything else, or?
Ron, I think that's it from my point of view.
Okay, Mr. Hussain, anything else from your side?
Just one thing. It's not to do with case management, but at the moment, the case against the second defendant is still maintained in fraud, alternatively in gross error. So it's just something to bear in mind about the gravity of the case. You know, that's the case we're dealing with. So that is what it is.
No, I understand. I understand that entirely, and no doubt you'll give me the usual submissions on what is necessary to prove and the enhanced burden and so on. Yes, we've all been through that before. Good.
Thank you.
In that case, Lord Marks, can I ask your instructing solicitors perhaps to put a draft of the order in with what we've discussed.
I'm sure they will. I haven't got instructions on that, but Mr. Mackenzie, the partner who is in charge of the case, is here, and he's just
Yes, I use the word "ask" in inverted commas there, by the way.
he's just unmuted himself, so I'm sure you'll get agreement now.
We would be very happy to, Your Honour. Not a problem.
Thank you very much indeed. Good. Well, thank you both for your very helpful and cooperative attitudes. I will, as I say, try and get a quick decision out on that document issue. And I very much look forward to seeing you both in person then in October.
Thank
Thank
you.
you very much indeed. Thank you. Bye-bye.